So my topic for today is health data and patient privacy, a legal perspective. Now, because this session was so delved into AI, this is going to be a little bit of a refresher course. I'm not going to go too into detail, and this isn't just AI specific. It's to do with all patient data that we're collecting. Right. So why does this matter? Now, your doctor-patient relationship is obviously built on confidentiality, and every patient that develops trust with you, it's because you promise to keep their data confidential. You're not misusing their data. You're not giving it out just like that. And also, the right to privacy has been deemed as a fundamental right. Now, I know this seems obvious, but this was only developed recently in, as you can see, 2017. And one of the most important developments is the Ayushman Bharat digital mission. Now, for those of you that don't know what this is, it's a new system that's come, like, you know how we save all our data with our DigiLocker and UPI, Unified Payments. Similarly, ABDM is trying to be a repository for all health data for patients. So it's like a national repository for the same. And because this is a growing aspect, I mean, some of you might be feeding it into your hospital information systems, your own softwares, which is why this topic is important. Now, I'm just going to go over the key legal framework, so the acts and laws that actually govern this. So, unlike the US, India doesn't have a specific law related to health data. It's governed by all of these acts. So initially, it's the IT Act, which covers the part about security and liability, the fact that you're liable for all the sensitive personal information that you carry, as in if you leak this data or if it is misplaced or misused by you, how you are liable for the same. And so the IT rules that came out in 2011 is what places health data under the definition of sensitive data. The latest act, which is also the most relevant, is the DPDP Act, which talks about consent, ownership, and erasure of data. This word lays the groundwork for what you're supposed to do with the data, how exactly you're supposed to take care of it, and everything along those lines. There's also a draft for the same act for a set of rules, attached rules, which is to come out soon, but it's not there yet. The Clinical Establishments Act from 2010 talks about record retention. Again, this is to do with how long you're supposed to store the data and for what purposes you can use the data. And the ABDM guidelines. The ABDM is the digital mission I was just talking about. So now the idea of this talk came with a conversation with my parents, where I think my dad asked me, okay, so now that I collect patient data, I feed it into one glance, I'm collecting their data, I'm getting these tests done, I'm storing all this data in one place. Does this data now become my data, or is it still the patient's, or now that I'm feeding it to the software, is it their data? I know all of these things seem very obvious, but when you think about it, I think, as I said, this is just an informative, little bit of a refresher course, but your patient will always be the true owner of their data. As a doctor, you and the software, the doctors, hospitals, everyone will be the custodian of fiduciaries, as in you will only be handlers of the data. You won't actually own that data. You can obviously use it for the purpose it's being collected, which in this case is to diagnose your patients or treat them, of course, to your software that you feed it into. And I think this is where it's extremely important with all this talk about AI and all the AI tools. Your software is a data processor only. So no software that you feed this data to will own any of the data you're giving it to. They have rights to process it, use it. Again, those rights are given by the doctor or the patient, which is why I'll come to the aspect of consent. I think Dr. Lok Modi mentioned it, and it's a very important point. I'll get to that. So again, just because you consent or give your data to these softwares or your doctors doesn't mean that there is any ownership transferred. Right, so collecting patient data. I know, again, all these things seem very obvious and might be taken for granted very often because in practice it seems very inapplicable to, constantly ask, okay, I'm collecting your data for this purpose, I'm going to keep it for this long, and are you okay with it? There's two kinds of consent, implied and expressed. So as a doctor, when a patient shares any history with you, any information, anything at all, and again, they give it to you willingly, it's implied consent. But when you specifically ask them, that I am going to collect your data for this reason, I need it, I need this test report for this reason, that is express consent. So again, when you're collecting patient data, it obviously must be lawful, it must be necessary. So you need to explain to your patients why you're collecting that specific data, why are you taking this history, and it must be proportionate. So the information you carry shouldn't be that wide. It should be very specific to the purpose or the diagnosis. And again, explicit informed consent. These are the keywords here for sensitive data. You have to tell them that I am expressly asking you for consent to store this data with me so that I can help you with your diagnosis. I can help you suggest your treatment plan, etc. And privacy notice. So again, it is important to inform your patients about the confidentiality that you hold with respect to their documents. And again, your collection of data can only be respective to their medical needs. Now, what can data be used for? Treatment and continuity of care, insurance claims. I mean, this is a little bit far off aspect, but it's still important to keep in mind. Government schemes, as in also this ABDF. Because they want to collect such a repository and it is going to start implementation soon. It's already in practice, but since it's going to be a growing thing, it's just important to note. And also medical research. Now, prohibited is, of course, sale and commercial use without consent. So say probably a pharma company, any research company for that matter, comes to you and asks you, okay, we're ready to pay you this amount of money, but we need your patient data. Can you do that? Absolutely not. The only scenario you can do that in is when you take consent, you give them, and again, you can't sell it, but you can share that data for that specific purpose only after taking express consent from your patients. So again, this is just same thing for data retention and deletion rules. This is basically just giving you a little bit information on how long you can hold it. Of course, in practice, most people tend to hold your medical records for a longer time so that you can develop your patient history. And again, because a lot of diseases, a lot of different treatments will be correlated, so you can maintain this kind of data in practice. Now, sharing and disclosure. Again, when you share some data to other labs, say, okay, now, for example, most people in the room are diabetologists. If they're referring it to another doctor and say, okay, I will send your reports across, you need to ask your patients, can I send your records across? This person, this colleague of mine is in this field, say a cardiologist. Can I share this data to them? You cannot just send it. I know in practice that's what happens and the patients don't have a problem with it, which is where it's implied consent. But to get rid of any legal liability on you, it has to be expressed. You need to ask them for permission. Without consent, only if there is any legal mandate. So there is a case law with respect to this. It's not that interesting or that relevant to most people in this room, but it's when you can break that aspect of consent and share it for the sake of public health or public good. In this case, it's an anonymous case, but say a hospital or a doctor specifically broke their disclosure to warn another patient with respect to an HIV case. In that case, the court ruled that you're permitted to, since it's in the aspect of public health and another person's health. So again, you need to ensure minimal disclosure. When is consent required? Collection for any health report, diagnosis, or disclosure to any insurers or third parties. And this is the most interesting and important and most relevant part with respect to this session. Uses for secondary purposes, research, training, and AI tools. Now, what I wanted to mention is we have spoken about using different AI tools for diagnosis. Can you do that? No. You're supposed to ask your patients, I have this report of yours. Can I use it? Can I upload it on any AI portal? I know, in practice, you can just upload any report. It can be anonymous, of course, but the best thing to do is ask your patient, okay, I have your ECG report. Is it okay if just, for the sake of ruling out all possibilities, can I upload it on ChatGPT or any other AI tool for that matter? even for training AI tools, I think that's what a lot of you over here are working on right now. Every patient data that is collected, you have to you require express consent for training these AI tools. So whoever's data you're sharing, it needs to be informed to them, or rather requested for consent to use and train these AI tools. Of course, it's extremely important because only then, I think that's what this session was for, the different kinds of AI and what can make AI way more accurate in the future. And again, cross-border transfer of digital health data. These are some landmark cases with respect to these are in general medical legal cases. I spoke about 2 of these already. The third one was basically no forced medical tests without consent. And in the sense, just because you might have some report of theirs, any data, and you think a procedure is necessary, you can't do that without explicit consent of the patient. So a simple compliance checklist: train everyone's staff on privacy obligations. Mention why, mention to your staff why you can't disclose reports, you can't disclose cases of any patients. Privacy notices. Now, again, this is not something we see very often, but it's a good measure to keep in case to avoid any legal liability. And secure your IT systems, of course. That's I think pretty obvious. And again, obtain written and electronic consent before using or disclosing. So the most important takeaway, I would say, is consent, right? Everything you do with your patient's data is tied to consent. So take specific permission. Specify exactly what you're going to do with that data, whether it's the smallest thing, whether I can send it across to a different doctor, use it for whatever purpose. Because non-compliance with this would put, again, ethical liability as per the MCI rules. And I think the MCI is now referred to as the NMC, which is the National Medical Commission. And I don't think anyone would want that liability upon them. So it's just better to handle patients' data with care, especially in the growing age of AI, where we feel like, okay, we can just use AI for everything. So I think this is the most secure way. And yeah, that's